Hey, my name is Jamahl Kersey. I'm the principal attorney at Kersey Law, a criminal defense firm. And I wanted to go over with you the 3 defense positions that someone would end up taking when they're charged with a crime. The reason why I came up with this was I was having a training recently with the team. We were just kind of going over our approach to cases. So I figured, why not give you guys an opportunity to see what we're thinking and what we're analyzing as we go through our defense and have defense strategy sessions with our clients. So here are the 3 defense positions, and just understand that these are factual positions. So we're not talking about legal defenses. You may have heard cases getting thrown out on a technicality, or a motion to suppress was granted and so the judge threw out evidence. So we're not talking about legal defenses. We're just talking about the factual scenario. So let's go through them. I'm going to list out all 3 and then I'm going to give you a description. And then as we get towards the end, I'm going to give you the art of storytelling and how we use this in order to put our clients in the best position to get a favorable outcome in their cases. So number 1 is going to be, it wasn't me. This is probably going to be the most rare of the scenarios, but it does happen. The police, they're human. They make mistakes. The reality is sometimes people get charged and it wasn't them. They were not the people who actually committed the offense. And so you might ask, well, how is somebody in a position where they're getting charged and they didn't do it? Well, sometimes you may have somebody who calls the police out of spite and blames them for something that they didn't do. All right, that's a possibility. You may have just a mere misidentification. So somebody legitimately thought that the person who got charged did whatever they're being accused of, but they really didn't. So they got it wrong and they reported it and they were telling the truth as they believed it. They just got it wrong. So that would be the possibility of it wasn't me. The next one is going to be, and this is one of the more common scenarios where it says, I did it, but just not to that extent. So let's just say, for example, we have a guy who's charged with a theft offense and robbery. So, and robbery is just a theft with force or fear added to it. His position may be, I took the watch, but I didn't use force or fear, because what you have to understand is with a robbery charge is much more serious than a mere theft charge. With a mere theft charge, it might just be probation, maybe a couple days in jail, or maybe no jail time at all. Whereas robbery, we're getting into possible prison time because you're actually using violence in order to take a person's property. So that's where we have the I did it, but just to not that extent. The last one is going to be, hey, you got me, right? So they got it right. The way it's being reported is what I did, and it just is what it is. The important thing to note is that there are defenses available to all 3 of these scenarios, and a defense attorney can absolutely help somebody who is in all 3 of these scenarios. You might think, hey, I did it, I should just plead guilty and whatever's going to happen happens. No, there's actually a lot that can be done even in a situation where it is you got me. So let's go over how we would approach each of these scenarios and kind of shed some light on what defense attorneys do given what the client's position is. So if it wasn't me, then this one is going to be very investigation heavy. We're going to eventually get the police reports, witness statements, photographs, videos, medical records, financial records, whatever the evidence is that the DA believes points to our client's guilt. We're going to get all that information and we're going to review it with our client. And so if his position is it wasn't me, then what we might be focused on is having our investigator dig up any clues or gather any evidence, talk to any witnesses, get any information that is going to basically help the DA understand that they got the wrong guy or they got the wrong gal. Now, bear in mind, the defendant is under no obligation whatsoever to prove anything in a criminal case. It's the DA, the government, the prosecutor who has the burden of proving guilt beyond a reasonable doubt. But even though that's the case, that's what's going to be the standard at trial. But, if it's a situation where our client didn't do it, we don't want to have to get all the way to trial to be able to clear our client's name. Whereas if we're able to just conduct some solid defense investigation, compile that information and get it over to the DA, that might be enough in and of itself for them to be convinced, okay, we got the wrong guy. Let's actually go after the person who committed the crime. So that would be the approach in number 1. In number 2, it's going to be kind of the same thing. We're collecting the information from our client. He's able to basically point out in the report, okay, this is a lie, this is an exaggeration, this didn't happen this way, this actually went down this way. And taking all that information, we might be able to just go off of what our client tells us and communicate that over to the DA in our negotiations so that we can make sure that they're only being held responsible for what they actually did. So going back to the situation, the guy is talking to another person and manages to basically finesse him out of his watch, but there was no force or violence being used, then that's just going to be a straight up theft. It might be theft by deceit, but it's going to be theft versus theft using force or violence. The alleged victim could say, oh yeah, he threatened me, and with that threat, then I gave up my watch and he took off with it. Our client could say, well, no, I never threatened him at all. I took the watch, but I didn't threaten him. And you can see from surveillance cameras, I never hit him. I never pulled out a weapon. I didn't say I had a weapon. So that muddy area is, where we're going to be trying to convince the DA that there was no force or fear of force being used. So we just have a straight theft case. So let's take it out from the robbery context and just deal with it as a theft. That's how we have here where somebody is being charged, but they didn't actually do it to the extent that they're being charged. Or let's just say there's a series of 100 fraudulent transactions to the tune of $500,000. And the client is being charged with this theft, being held responsible for $500,000 worth of transactions. And he's like, hey, listen, out of those 100 transactions, I was only involved in 3 of them. I colluded with some of these people and I was in on it and everything. But listen, I should not be held responsible for this $500,000 in transactions when really I was only in on 3 of them and I really only gained around $2,500 to $5,000. If we're talking about $5,000 versus $500,000, that's a huge difference. So we're not saying it wasn't me, right? So he's not saying like I didn't have anything to do with anything. No, he's saying, hey, listen, I'm in the neighborhood of what happened. The only thing is it's not to the extent I'm being charged. So in that situation, again, pointing out based on what our client is telling us, hey, listen, this is what actually happened. He's willing to admit to the 3 transactions in which he was involved. He's willing to pay restitution on the $5,000, but for that other $495,000, somebody else is responsible for it. And so our client's not going to be held responsible, or he should not be held responsible for that. And so this last case scenario is you got me. The police, they conducted their investigation, arrested our client. The DA reviewed that information and decided to file these charges. We get the evidence. We go through it. Our client is more than willing to admit, hey, listen, I did it. They got it right. There is no factual defense here. And that could very well be the case. Like I had a case years ago where a guy was being charged with possession for sale of a controlled substance. They searched the home. They found the drugs. They got his phone, went through the phone. There was text messages. It was clear that he was making arrangements to sell his drugs to people. They had him dead to rights. It was a you got me situation. There was no argument that was not the case. But like I said, in each one of these scenarios, there's still something that can be done. And this oftentimes is the most important aspect of our defense. It is context and mitigation. When we're talking about context and mitigation, we're talking about the art of storytelling. And it is so vital to a defense. And so as part of our defense, in any case we get important information from our client because we want to know who they are as a person. When a person is charged with a crime, they're being reported on what could be just a mere 5-minute situation in their whole entire life. A lot of times when we're talking about your run-of-the-mill case, we're talking about a factual scenario that only took place over the course of 5, 10, maybe even a half an hour. So we're not talking about that much time. So we're talking about one incident compared to if the person's in their 20s or even 30s or 40s, they have a whole rest of their life that they may have done some amazing things. We have clients who are volunteer soccer coaches, churchgoers. They organize fundraisers. They feed the homeless, college students, doctors, lawyers, wonderful brothers, great moms, best dad ever, all these different types of things. But the only thing that police have in their reports is they're just reporting on the crime. They're generally not putting any positive things whatsoever in a police report. And all the DA knows is what the police have told them. So they have no context either. They don't know anything about our client unless and until we provide that information to them. So that's where we have extensive interviews of our clients to find out, who are you? What do you do? What What do you love doing? What are you passionate about? What are your future goals? What are your hopes and dreams and aspirations? What's your education? All these different type of things can make a huge difference. Even in a situation where the DA and the police got it right, there's a story behind everything. If we can show why this happened, and almost more importantly, show why this will never happen again, then that can be the biggest part of a defense strategy to get a case dismissed, or in the majority of situations, be able to negotiate something where they're ideally able to stay out of custody, avoid a felony, and move on with their lives. If you got something out of this, please be sure to hit the like button, subscribe to the channel if you haven't already, and turn on the notifications button so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.